These cases were always from our communities. Plyler versus Doe, a case that correctly recognized the right of every child, regardless of immigration status, to enroll in public school, but that refused to apply existing constitutional law or recognize even undocumented children as a suspect classification. And in the case of the LGBT community, Romer versus Evans and Lawrence versus Texas, cases that came to the right result, but refused to take the steps necessary to recognize on an ongoing basis the need for full constitutional protections of the LGBT community. But this fifth similarity, being outside of the full protections of constitutional law, brings me to a brief discussion of comprehensive immigration reform. At MALDEF, as a legal organization grounded in respect for the Constitution, the number one reason why we need congressional enactment of comprehensive immigration reform is to finally introduce and maintain our constitutional values in our immigration system. As a nation, we often engage in self-congratulation, and we rightly celebrate the fact that in 1965, 45 years ago, we abandoned a facially discriminatory immigration system that was designed to skew in favor of European immigrants. But what we do not acknowledge is that 45 years later, we continue to have a discriminatory immigration system. Our system is grounded on the basic principle that every nation should have the same limits on immigration, regardless of proximity, cultural connection, or even population of that sending country. What that means is that the sole determiner of whether you will wait 4 years to get a legal immigrant visa or 23 years in the same category of immigration, the sole determiner is what country you come from. That is a system that is inconsistent with our constitutional values of equal protection and non-discrimination, and we must change it. We also have developed a system under which the courts provide complete discretion to Congress in determining what our immigration laws will be. And as a result, we do not provide due process in our immigration adjudication system. We have a system that does not provide legal representation, sometimes does not even provide a hearing, often does not provide adequate interpretation in making decisions that are life and death for families. We must reintroduce our constitutional value of due process to our immigration system. We have an immigration enforcement system that permits both federal and local law enforcement to make assumptions based on race, language, appearance that would never be allowed in other contexts, but that allows those assumptions to be made in the context of enforcing our immigration laws. That is inconsistent with our constitutional values, and we must reintroduce our equal protection values to our scheme of law enforcement on immigration rules. What that means is outlawing the racial profiling that is too prevalent throughout the nation, beginning in Arizona with Sheriff Joe Arpaio, but extending throughout the nation. We must reintroduce those constitutional values. And in an issue that I know is particularly meaningful to the LGBT community, we must reintroduce equal protection values into our definition of family under our immigration laws. There has been an ongoing debate in the civil rights community about whether we should hold out for comprehensive immigration reform or act on discrete, important principles directed toward a comprehensive overhaul of the system. I have concerns We need to know what comprehensive immigration reform will mean. Recently, Representative Luis Gutierrez out of Illinois introduced a bill, a comprehensive immigration reform bill. There is much to love about that bill. It includes many of the things I've talked about, reintroducing through Congress constitutional values to our immigration system. But first, among its flaws is its failure to include the Uniting America's Families Act as a portion of its provisions. Now, that doesn't mean that we shouldn't endorse and move forward with a bill like Luis Gutierrez's, but it does mean that as a community we must work to make sure that the comprehensive immigration reform that we are given is truly comprehensive in introducing all of the constitutional values that I mentioned to our immigration scheme. I have been outspoken in saying that if we cannot get comprehensive reform in 2010, we need to move forward on elements of reform as down payments, by which I mean recognition that ultimately comprehensive reform is absolutely necessary. We must demand of our leaders in Washington that they comprehensively fix our flawed immigration system. But how they fix it, through one bill or several, is of less importance to me. What is important is that we stand united in insisting that comprehensive reform be just that, comprehensive in dealing with all of these issues, including the Uniting America's Families Act. I believe that the most critical elements of comprehensive reform that we must not delay in moving forward are the following: the DREAM Act. An act that would acknowledge the potential that we are wasting as a nation by refusing to accord legal protection and status to young people who succeed in our education system. We must, as a matter of our national interest, just as much as a matter of our constitutional values, move on enacting the DREAM Act. Second, ag jobs. A provision that would acknowledge that there is one industry, perhaps more than any other, although there are others, where the lie that we can provide a workforce for this industry from within our own country can be demonstrated. Agriculture is an industry that must depend on immigrant labor, but we must provide full protections, legal status, and a pathway to citizenship for those who labor in our fields. A third critical component, and I've said it several times, that we need to not delay in moving forward is the Uniting America's Families Act. Its importance extends beyond the reintroduction of constitutional values that I discussed previously. This is an act that would once again confirm the centrality of family to our immigration system. Every time this nation debates our immigration system, there are those who would argue that the primary determinant of who should be allowed to immigrate should be on skills, labor, money, crass, superficial indicators of what seems to be in our nation's interest. But time after time, as a nation, we have concluded correctly that the central element of our immigration system must be the family and reuniting families. Recognizing and enacting the Uniting America's Families Act would once again clearly state that our national values put families of every kind at the center of our immigration system. And that's why I believe that the Latino community, the LGBT community, and any civil rights-minded individual has to support moving forward with UAFA. As you can see, I believe that comprehensive immigration reform demonstrates our common cause. Our two communities have a history of collaboration and partnership that we can be proud of. Comprehensive immigration reform presents another opportunity for us to strengthen that partnership as we move forward. Once we succeed there, we will continue to work on other issues in our enduring, durable movements to ensure that together we can create change and move this nation to a more progressive America. Thank you very much.